morning, everyone. I'm very happy to be here in Kuala Lumpur after 10 years. My last visit was 10 years ago, and I find that I feel as if I'm back at home again when I come. Always I feel this when I come to Kuala Lumpur and to Malaysia. Now, let me talk of access to information in Sri Lanka, or as we refer to it, the right to information. And I agree very much with the previous speaker that this is actually a right. So it is not a privilege, it is very much a right. And let me really illustrate the potency and the power of right to information in Sri Lanka by two examples. Now, the Rti Law, as we refer to it, came out of a 15-year-old struggle in Sri Lanka, and it was enacted in 2016 August. It has been ranked the third best globally and the first in South Asia. But to that, the law is just in theory. The theory and the practice are two very different things. Now, when the act was enacted in August of 2016, we took only 6 months to operationalize the act in February of 2017. And on the very date of operationalizing, February 3rd, in the eastern province of the country, which is a very remote province affected by war for the last 3 decades, a group of mothers of Tamil ethnicity, as many of you in the hall know, Sri Lanka has one majority ethnicity, the Sinhala ethnicity, and you have Tamil and Muslim ethnicities as the minority ethnicities. Now, in the eastern province, 15 mothers of Tamil ethnicity took copies of the Tamil Right to Information Act and went to police stations in the eastern province, waved the act in front of the faces of the policemen in the police stations, and wanted to know what had happened to their children who had been disappeared during the end stages of the conflict in 2009 between the Liberation Tigers of Tamil Eelam and the government of Sri Lanka. Now, this was an unprecedented situation. The police officers were completely unaware that an act like this had been enacted. And moreover, it is now changing a little bit, but at that time, many of the policemen serving in the eastern province and in the northern province were really of Sinhala ethnicity, so they couldn't understand Tamil. They couldn't read the language, they couldn't understand it. So when the Tamil mothers came with the act, they were completely nonplussed. And they said, we can't understand, we can't understand what you're saying, we can't read this document. And the mothers ended up explaining to these policemen in Sinhala, which they knew, because they had to, what the act was all about. What gave them the right to come to the police stations and ask for these answers about their children from the policemen. Now, to many, it may seem a fairly mundane occurrence. You go to a police station, you file an inquiry, But this was not mundane. It was extraordinary, because for 3-4 decades, to survive in the north and east of Sri Lanka, one could not ask questions. If you had to survive, you should not ask questions. And this was a very definitive empowering of women, not only to go to a government agency, to go to the police, which was extraordinary, and to ask for answers. Now, what happened therein was that as a result of their asking these particular questions, they initiated an inquiry into the disappearances, which is now ongoing, and that process is taking place. There's a second example that I just want to illustrate to you about, again, to show what a difference RTI and access to information has made in Sri Lanka. And this is regarding an application filed to the RTI Commission, of which I'm a member. The Commission is an appellate body. It considers information requests that have been denied by the public authorities. And an appeal was filed before the Commission by the Pilots Guild of Sri Lanka. There is a national pilots organization asking for information regarding the salaries of the CEO of Sri Lankan Airlines, the country's national carrier, and other top executives, and benefits given to them, as well as documentation relating to certain aviation agreements that have been entered into between Sri Lankan and other aviation firms. Now, there was a background to this here. This was in the context of gross corruption in the national carrier for the last 2 decades or so, whereby once profitable airlines had been run virtually to the ground as a result of very bad management of the airline, major corruption by all political parties and by governments in Sri Lanka, and it was running at a loss. It was actually being run, and it is run now through funds by the Treasury. Otherwise, it would be bankrupt. Now, Sri Lankan Airlines resisted the information. asked for with all guns blaring. So it came before the commission with a battery of corporate lawyers. It raised every trick in the legal book. It raised points of law, substantial as well as procedural, and said we cannot give this information. After 6 months of very heated hearings, actually, the commission handed down a 25-page order 2 months ago, whereby it ordered Sri Lankan to give all the information asked for, excepting one, which was concerning negotiations between Sri Lankan and Airbus SAS that was ongoing at the moment. And after a month, Sri Lankan complied with the information direction by the commission. It gave all the information. In between that hearing, the CEO of Sri Lankan took early retirement. The entire board of Sri Lankan Airlines changed. A new board was put into its place. And there was major public furor around the fact of the national carrier and all the corruption that had come to light. So now 2 examples that I've given you. One is from the villagers, and one is at the highest level of corporate accountability, showing how RTI has actually directly benefited the people in Sri Lanka. Now, apart from these 2 examples, there are, of course, many more. The commission itself is also a very new commission. We've been in operation for just 1.5 years. I'll give you some more details about what the commission is all about a little bit later. But we've handed down hundreds of orders up to now, and public authorities in Sri Lanka have actually complied with the Commission's directives. There's been no public authority that have said, we are not going to obey you, we are going to resist you. We are going to the Court of Appeal, we are not going to give you the information. They have not really said that. They have all complied. There are 2 reasons for this. One is that the Commission itself, when handing down the orders, don't actually order information release in all the cases. There's a fine balance being struck between the right to information and the right to privacy, to national security, to other issues that must be also considered. So there's a balance between the 2 rights that are very carefully engaged in by the Commission, because we are aware of the need that the RTI Act must not be resisted by the establishment or by the public servants. That's a very strong concern that the Commission has always been having. The second issue is that our orders are also very carefully reasoned. We don't just give administrative orders or 1 paragraph saying release the information. There are legalistic reasons being put down as to why information ought to be given or should be not given in the first instance. So among the other information released by the Commission and due to the Commission's orders are commissions of inquiry reports. Now, Sri Lanka has had a habit, I don't know how it is in Malaysia, Sri Lanka has had a habit where the President appoints commissions of inquiry to look into various issues of high-level fraud, corruption, disappearances, human rights violations, and the reports are never released. Now, in one particular case, there was a very suspicious death of a cabinet minister 10 years ago, and the President appointed an inquiry committee to look into this matter, to inquire into the matter of this particular person's death, and the report was never released. It was hidden away. So there was a request made to the Commission that people wanted a copy of the report, and the Commission then went on an inquiry. And the report is missing in the National Archives. It was missing in the Office of the President's files and drawers. Ultimately, it was found deep in the bowels of the Criminal Investigation Department, the CID, and it was then released to the public. Then there are other examples, and I could really give you many, many more examples, ranging from procurement, from tender issues in particular state entities, so on and so forth. We have released instances of migrant workers treaties being entered into between the government of Sri Lanka and other governments like Qatar, Kuwait, Saudi Arabia, so on and so forth. We have released draft laws. In Sri Lanka, there's a practice whereby laws, when they're being drafted, are not really released to the public. They're released only when the matter comes up before Parliament, and then only within 2 weeks of the draft bill, you have to challenge the bill in the Supreme Court. Otherwise, you have no way of challenging it after enactment, even if the bill is unconstitutional. So here, in this case, 2 bills that people wanted access to. One was in reparations to victims of the conflict in Sri Lanka, and the other was the bill related to the draft bill related to disabilities of people. Both bills were released after the Commission issued orders. Now, let me just say this also. The Commission's orders that I'm talking to you about at this point of time represent only a percentage of the right to information requests in Sri Lanka, because they come to the Commission only when that has been refused by the information officer at the lower level. During the first so many months of Rti Law being enacted in Sri Lanka, the amount of information requests filed each day were 100. More than 100 were filed each day. And RTI became like this thing where you went to it for everything that you couldn't find. Normal service delivery, government permits, car permits, land deeds, whatever. It was basically, sort of seen as a panacea for many, many years in Sri Lanka, and people kept going to RTI Act and filing these requests. Now, a little bit of the history, though I won't go into it in detail here. In Sri Lanka, the Rti struggle was not a people's-based struggle like in India, for example. It was led by a group of lawyers, academics, and activists in Colombo, who basically started their process 15 years ago. And there was a bill in 2003, 2004 that was passed to a parliament but not enacted. And then ultimately, when the government changed in 2015, we had the struggle for Rti coming back into the process again. Earlier, during the Mahinda Rajapaksa decade, where we had a president and his brothers controlling about 99% of the national budget, there was no possibility of information law in any sense whatsoever. The president at the time actually said that we don't need an information law, that he is the fount of all information, and anybody wanting information could come to him and ask for information. That was the extent of the state resistance to information that we had at that time. So 2015, there was a new sort of government in place, and they said, okay, we have to enact this law, and then we were called upon to draft a law and give it to the government, and Parliament actually passed the law with almost 99% of what we wanted. So in theory, the law has been quite proactive and quite good. In practice, also, it has been quite good, as I explained, but of course, there are challenges, and I'll talk a little bit about the challenges. So the first challenge is this. As I said earlier, Sri Lanka did not have a people-based RTI movement. It was a more elite kind of movement in the city. But the Rti law has been used very much by ordinary people in Sri Lanka in very remote places, in very remote parts. So that is a positive factor. But because it has not had a people's movement around it, the possibility of governmental change in the future, with a new government coming in, what could happen to the right to information law in Sri Lanka is very much a problem, because ultimately what will foster and keep a law strong is a people's pressure and a people's movement around it. It must become part of a civic democracy strategy in the country. In Sri Lanka, it is not yet happening, though it is going on towards that, is yet not happening. Now, the second concern that I wish to mention is the fact of threats being leveled against people using the Rti. So you do have instances where communities and individuals are using Rti, are being threatened by particular sectors of the government. Not many, not all, but particular sectors of the government. And the threats are coming in very indefinite ways. For example, they don't say don't file Rti, but what they say is, well, we're not giving you benefits if you file Rti. So it's very indirect. They're not really challenging directly. And then we've had instances where journalists who have used Rti have had intelligence reports being maintained on them from the security forces. So the culture of change, as was mentioned earlier as well, is important to note that a law cannot really change a culture. That has to be more gradual. And in Sri Lanka, this culture is being changed, but still we have a long, long way to go. So if the possibility or the phenomenon of threats being leveled against information requesters become widespread, then we will certainly have a problem as we go on. The third point that I want to mention is, again here, the law has been used and drafted in a way that is very adversarial, it's very challenging. You go to a government office and you challenge them, and you say, give us the information. But the importance of Rti comes in proactive disclosure. It comes in voluntarily giving the information. The government voluntarily realizing that it's good for its own culture and is good for its own establishment to give the information. And the proactive disclosure element of the Sri Lanka's information regime is extremely weak at the moment. That has to be really developed. I would like to conclude by making one concern very strongly felt. As Sri Lanka really goes on in its information path in the future, we really need to look at ways and means in which information is considered to be part of an overall general discourse among the people in the country. We have had instances where information release has led not only to the mere release of the information, but people challenging governance and government itself. So for example, we had a very good instance recently in the North Central province where there had been major corruption in the building of tanks and roads in that particular area. And because of RTI, because villagers filed RTI applications, they discovered the fraud, and the money was returned to government. The public officials were actually dismissed from their office, and they built the tanks and the roads all over again. Now, this was a good example of the people coming together from a very remote area of Sri Lanka and actually getting on the streets and demonstrating and asking for things to be changed because of right to information. We need to find that happening in a lot more, in a lot more diverse instances in Sri Lanka, not only in one instance, because that is the only reason why RTI law in Sri Lanka will be safeguarded in case of any changes in the future, politically or otherwise. Thank you.